I run this peer group. This peer group is under AGED. You all know AGED as a pooled trust provider. They also have lots of programs to help guardians. This is one of them. You may know of the Benevolent Fund. That's one to help you and your attorneys get paid for your indigent guardianships or pro bono guardianships. We also have CHG, which is a hospital program for cases that you get asked to take and paid for by the hospital or by an attorney representing the hospital. All those programs are under AGED's umbrella. And this group, this peer mentor group, is another one. So today our speaker is Winter. Winter has been a court monitor at Orange County for forever. I don't know how long, Winter, you get to tell everybody, but for a very long time. And she recently did sort of this version of the presentation for the Central Florida chapter of FSGA locally in person. And I thought it was super helpful. And I learned a lot. I've been doing this for 30 some years, but I still learned a lot. So I feel like you guys will learn a lot from
I feel very bad for you. I really do.
Oops. Hey, Judy, we can hear you, hon. There we go. So Winter, I think I'm going to, let me make sure there's nothing in the chat that says anything that we need to handle. If anybody's having any tech problems, you can email Kate at AGED. You can call the AGED office. You can send her if you have technical problems, Kate's the one to speak to.
Yeah.
All right, Miss Winter, I would like you to do a short introduction of yourself and then get started.
Hi, my name is Winter Solomon. I am the program coordinator for the Guardianship program in the 9th Judicial Circuit Court of Florida. So that's Orange and Osceola County. I've worked here for almost 21 years. So I've been doing this a long time. Never thought I would be doing this long. But I do love my job. So as the court monitor, I actually have 2 case managers. One I have here in Orange County and one in Osceola County. I do investigations pertaining to guardianship, and I am employed by the state of Florida or the 9th Judicial Circuit Court of Florida. So I don't get paid outside, aside like an attorney would. My pay is whatever the state of Florida pays me. So yeah, so that's my job. I'm sure pretty much everybody here is a professional guardian. Am I correct? Or that's just my assumption.
Public professional guardians and their staff, and that's all who's on this. That's it.
Okay. So then pretty much everybody knows the basics of guardianship, but I don't know if you all know how we actually came about having to establish guardianships. It's become a huge thing, especially since the aging of the baby boomers. There are a lot of us, I am one of them, who's turning 65 before the year 2030. And we are all considered baby boomers. I am 65 now. And so with the aging of the baby boomers, you have people who are not necessarily prepared to age, or, they haven't done their homework. They haven't prepared for aging, like doing their durable powers of attorney or their legal paperwork that's needed so that if something happens to them, they can avoid guardianship. Okay. And then in some cases, they've done the paperwork, but then you've got family members who fight. And so they end up in guardianship anyway. Other ways people end up in guardianship is, an absent parent. Somehow parents are killed, or they are in prison, or just absent for whatever reason, and someone needs to be the guardian of a minor child, or they need to be guardian of the property of a minor. Numerous ways. Kate, you can turn the page. So in guardianship here in Orange County, Florida statutes allows us to do background checks, or what we call level 2 live scans. So in Orange and Osceola counties, we do require a level 2 live scan. Not every circuit does that, but we do. The statute says that a felon or someone who's convicted of a crime that's generally dealing with moral turpitude, such as prostitution or assignation for prostitution or indecent exposure, can't be a guardian. So the only way that you would know if a person has been convicted of those things in many cases is to do the level 2 live screen. We've had many people who have said, "Oh no, I've never been arrested," and they just got out of prison. So, so we don't take that for granted. We know that people are often less than truthful. And so we do the level 2 live scans, and we require it before the case goes to court. If they're going to be guardians of the property, then we run the credit. The professional guardians, we run credit of a professional guardian every other year. We don't do their credit every year. We don't do family guardians every year either. I will do a family guardians if I get appointed to a case. I will run a family guardian's credit if it's dealing with money and it's been it's been more than 6 months since that person was appointed. I'll run their credit again if it's dealing with money. But generally speaking, we try not to run people's credit if we don't have to, because that's a hard hit on a person's credit. And we do understand that. Trying to think what else. Okay, turn the page on this one, please. There you go. So we've talked about the aging of the baby boomers, and another reason for having guardianship is because of HIPAA, which is the Healthcare Insurance Portability and Accountability Act. People assume that if you go to the hospital and that's your husband, that the people at the hospital are going to tell you everything you want to know about what's going on with your husband. But that is not necessarily so. And so oftentimes when hospitals or doctors don't have any information otherwise, they will often tell the people they need to go and get a guardianship or open up a guardianship case, because they don't have anything that tells them what to do instead. Like, for instance, that person hasn't signed anything saying, I want my wife to be able to make decisions, or I want my wife or my husband to have this information about my health care and to be able to make these decisions. And so without that information, they will oftentimes require family members to go out and establish a guardianship. Okay, turn the page, please. Guardianship is a legal relationship created by, it's created by the court. And a parent is the legal guardian of their underage child. So once that child turns 18, it doesn't matter what that person's abilities are. In the state of Florida, once they turn 18, they legally have capacity. So you will have to go to court to establish that, let's just say your child maybe was developmentally disabled and learning impaired. And so you need to be able to make decisions for your child that's severely learning disabled or whatever their condition is. And you can't do it. The school won't tell you anything because that child has turned 18. And you're thinking, well, I'm his mom. And they say, well, we don't care because he's 18. And once a person turns 18, they have all the rights you and I have, regardless of their ability. So you have to go to court and establish that that person is in need of help and that you're the person to help them. And I have a lot of parents who get very angry because they say that they've taken care of this child all of their lives. And then when we do the background checks, we find that that child has been adjudicated dependent as to that parent, and that parent's been to prison. And, the parent's credit sucks. And so, but they want to be guardian. And they've said that they've taken care of this person all of their lives. And it's clearly not true in many cases. So the court's job is to protect that person, that proposed ward or that ward. It is not we have to appoint a guardian, but what we try to do is make sure that the guardian we appoint protects the ward, because that's ultimately what it's all about, is protecting the ward, making sure that that person's financial security is safe, and making sure that that person's being is also safe. So that's what we try to do here in Orange and Osceola counties, and I'm sure in every court. Just every court doesn't have my corresponding person. So next slide, please. So we've already gone over sometimes why guardianship is needed, so we can go to the next slide. And I'm sure there are a lot of reasons people need guardianship, so we can just keep going. Go to the next one. Okay, so there are two different roads. Okay, I don't know, most of you are professional guardians or work for a professional guardian. So there's guardianship of an adult. And of course, for that, you have the petition for incapacity, the 3-person examining committee, and the attorney for award is appointed. The guardian application is filed, criminal and credit check, reports received, and the hearings held. But I don't know how many of you have ever done the guardian advocate side, which is under 393.12. So for that, it's a little bit different. And the difference is that you don't have an examining committee. And the reason for that is because for guardian advocacy, you should have a well-established medical history and social history. So you really don't need that 3-person examining committee. The medical records can establish that that person has autism or cerebral palsy or Prader-Willi or whatever the condition is that qualifies them for that. And it has to be a qualifying disability. In other words, that person who became schizophrenic at this age of 17 does not qualify under guardian advocacy. They have to have a condition that occurred at or near birth, and there are some very specific ones, such as Down syndrome, mental retardation, autism spectrum, Prader-Willi. There are a few others, but mental illness in and by itself does not qualify someone for a guardian advocate. So if your 17-year-old child just became schizophrenic or is now suffering from bipolar disorder, they don't qualify under that unless they have one of those other conditions that goes along with it.
And Winter, I'll bring up for a second, because the vast majority of folks that are dealing with these are clients who are well above 18, 19, 20, 21, well above that younger group. Mm-hmm. Often guardians get involved, professional guardians especially get involved in these cases when the person is, north of 40.
Yes.
So we have the whole other complication of dealing with APD and proving their disability under those same medical diagnoses to get APD and Medicaid and guardian advocacy, which kind of all play together. Yep. So if you're a guardian and you're kind of new to guardian advocacy, understand that different than under 744, when their disability happened before age 18, and if it can be proven with school records and hospital records, that's kind of how you have to have the medical diagnoses that create them the ability to be in the guardian advocate concept versus 744.
Right. And if you can get the records, really what ends up happening in many cases when you end up with somebody who's 40, 45, and you're becoming their guardian advocate, oftentimes it's because that person's parents have passed away, and the person's parents kept them home with them for the last 30 years or last 20 years since they've left school, and they haven't been socialized. And so you're oftentimes trying to find records and things to verify that that person's condition was established before they turn 18.
Yeah.
And that is not always an easy thing to do. And I can tell you, schools are now keeping records for less and less time. But what I would tell you is, if you are going through that person's homes and going through paperwork and that kind of thing, don't take anything for granted. Look through every magazine, through every book, because people secret things away, and you might find that little piece of paper that tells you exactly what you need hidden away in a magazine. I can tell you that because I have a 90-year-old mother who puts stuff that she shouldn't put in the middle of books or in the middle of magazines. And she'll say, well, I knew where I put it. Well, yeah, but nobody else did. So, you know, just make sure you're checking everything, because things do turn up in places you would never think that they would. But yeah, they have to have a well-documented social history. Once you file that petition, an attorney is appointed for that ward, but you as a guardian advocate don't have to have an attorney. So
well, Winter, can we specify that that's relevant if there's no guardian of the property?
right. If there is no guardian of the property, if it's just guardian advocate of the person, then you are not required to have an attorney. If it is guardian advocate of the property, yes, you are required to have an attorney.
And so one little comment about that is, as a professional guardian, you should try very hard to never have a guardianship of any kind that doesn't have legal representation for you.
Right.
So when you're asked to do a guardian advocacy, have a discussion with whoever's talking to you about this, about the ability for you to have an attorney to represent you, even if there actually isn't any property other than the Social Security check. Because otherwise, if you have any issues with the courts, you have no legal representation, different than 744.
Right.
In guardian advocacy, you're not mandated to have a attorney represent you unless it's guardian of the property. But think long and hard before you accept a guardian advocacy without an attorney to represent you.
Yes, because you still have the same responsibilities. You still have to file those annual plans. They still have to go to the doctor every year. That's still on you. It's just you're not required to have an attorney to do it.
Right.
So just make sure that you know what you're doing and what you're getting into, and that if you're going to do that guardian advocacy, make sure you've got a tickler system that's going to tell you, oh, it's time for him to have his physical this year. And generally, if you've got somebody who's living in a group home, generally speaking, the support coordinator will help you with that. But it's not the support coordinator's responsibility to do that for you. It's your job. And the court is not going to go to the support coordinator and say, hey, why didn't you remember to talk to that guardian advocate, the court's going to say, why didn't you do your job? That's what they're going to say.
And the other warning to that is, you know, APD is changing.
Yes.
Support coordinators are changing, government programs are changing. So the reason why I want you to think long and hard about taking a guardian advocacy case without an attorney is exactly that. You are without an attorney. And so if you have to deal with something in the courts, you are acting pro se for your own self. And that's not what you want to do if you can avoid it. So just a little warning.
And if, you know, unless you've been doing this for a while, I would say, and you're really confident, I would say avoid it. That's what I would say.
Yeah. Yeah.
Okay, next page, please. Okay, so all of the rights that can be removed for a person who's been incapacitated, I'm sure you know what they are, and the rights that they can retain. You know, if a person is incapacitated and they don't retain the right to contract, they automatically lose the right to marry, unless you ask specifically that that person retain that right. Because in the state of Florida, marriage is a contract. So remember that you can't let let your wards get married without first seeking court approval. Let's see, generally they lose the right to vote. A lot of times with veterans, sometimes people are hesitant to take a veteran's right to vote, but generally speaking, nowadays they're going to lose it anyway. To personally apply for benefits, a driver's license. Some people say that's a right. To me, that's a privilege, but and the right to travel. I don't know. Sometimes people think that, yeah, oh, I can let them go to England without the court knowing. No, you can't. If that ward is traveling outside of the jurisdiction, you need to first obtain court permission for that ward to travel outside of the jurisdiction. Okay, that person cannot go to England without court permission.
And one of the reasons, guys, that you would want court authority is if something goes wrong in England. You know, if you let them go out of the state of Florida, talk to your attorney about where that line is drawn. Is it at the county line where your ward's venue is residing, or is it the state line? Your circuit and your attorney may have an opinion about how far out of the area is, whether it's county line, the state of Florida line, the border of the United States. But in any event, if your ward is going to be traveling and you're coordinating it, using the ward's money to pay for it, and you're managing everything, you want a court order that protects you. And in that court order, you want it to address some of the possibilities of, if something goes wrong, what's your plan? If you put them on a cruise with a caregiver, what's your plan if something goes wrong in Jamaica?
Right. So I know a lot of times guardians themselves travel, professional guardians travel. It used to be a thing where you pretty much had to get somebody to substitute for you, and you would have to go to court and get somebody to do that for you. But nowadays, with so many ways to communicate, I don't know that it's, unless you have somebody who's really very medically involved, that it's all that necessary, as long as you're able to maintain communication with the hospital or the group home or whomever the caregiver is. Like I said, it used to be you really needed to have somebody, but now with cell phones that, you know, you can talk to people all over the world. You know, we've got Skype and Zoom and all of these other things that you can use. You don't necessarily need to have somebody who's going to stand in You may feel more comfortable, especially if you're going to be in some place that's really remote.
Right.
But in most cases, I would say that it's probably not that necessarily, unless you're going to be somewhere that's really, really remote.
That's a good point. Winter, we got a question from Amy Herring. She says that's only for guardian of the person, not property, right? And I think she's talking about the conversation we were having a few minutes ago. Amy, yes, guardian of the person as it relates to guardian advocate, not
Right, not
right. 744, you need an attorney, whether it's person or property or both. But
Right.
under guardian advocate, you're correct. If it's guardian of the person, you're not legally required to have an attorney. Just talk to your attorney about whether that's a good idea or not for you to be represented without. Oh, she says, I was curious about the travel conversation. Oh, okay. Well, here's an interesting comment. So guardian of the person and guardian of the property are actually involved in travel, because if there's guardian of the person, that person's agreeing and arranging the travel, but the guardian of the property, if that's a different person, is paying for it. So in that case, if there was two guardians, both guardians should be involved in the petitioning and the authority, because if something goes wrong
on either end,
of the person and the guardian of the property will be involved on the other end of getting them back to Florida.
Right.
Yeah.
Good so question. They both have to work together for that.
Yeah.
You're not working in a silo as you would think it would be.
Rebecca Ross. Rebecca's got her hand up, a yellow hand. Rebecca, you want to come up and mute and ask your question? Or am I reading that?
Sorry, I'm here. I just could have, I was trying to
There you go. There you go.
And I apologize. This might be rhetorical. It's just because I do get the guardian advocacy kind of mixed up a bit. But if a prospective ward would be like if they had cerebral palsy, but it was after they were 18 and there were no kind of prior, it was the diagnosis, but would it be because you wouldn't be a guardian advocate, you would be just like plenary guardian or limit, like, or would you, I just didn't know how that part kind of confuses me a little bit. And okay. I was hoping if I could have clarification on it. I apologize.
Okay, so cerebral palsy is a condition that someone is born with. That is a birth defect. So that would fall under 393.12. Okay. So just like autism or Down syndrome or mental retardation or Prader-Willi or a number of other conditions would fall under 393.12.
Well, if it was kind of like in the if it says CP, but then mild mental retardation, I just didn't, that's kind of the thing. I just didn't know if there's kind of overlap there.
It's okay. So even if it's mild, it still falls under 393.12. Okay. Technically the statute says that you can use 393.12 if that person can exercise at least one right. That person's supposed to be able to exercise at least one right under 393.12. But in many cases, the court will allow a guardian advocacy even if that person can't exercise any rights. And sometimes that's because those parents are really the caregivers and they're applying to become the guardian. And most parents just don't have the money to keep an attorney on retainer. And it's very expensive. I mean, you all know how much it costs to have a guardianship, to establish a guardianship and that kind of stuff. And most parents, I would say, just don't have the $5,000 laying around to go hire an attorney and then the money to do the annual plan and that kind of thing and to pay them for it and that sort of thing. So that's why 393.12 came into play.
That makes so much sense. Thank you.
Yeah, and Rebecca, if you think most cases that 393 started out with was the parents of a kid turning 18.
Right.
The vast majority. Right. Because the minute they turned 18, technically they were competent, and it didn't matter if they had an IQ of 61, they were legally competent. So
Right.
it was really not for the adult guardianships of someone at age 72 that has a massive stroke and becomes incapacitated, can't speak, that's truly just 744. But there are times that your attorney or a case, they may decide that it is better served under 744 than under guardian advocacy. There are times that attorneys make that call for the unique situation to that family. So
Okay. No, thank you. I
There you go.
appreciate it so much.
there you go.
Yeah, and they will often do that, especially if it's a situation where there may be a lawsuit pending. They will go for the 744.
Yeah, yeah. So here's another question or comment. Patricia says, in regards to travel, I would take my ward to another county for the day to have fun, but leaving on vacation out of state, I would get a court order. Right. So this is for your circuit and your attorney and you to decide how far is travel to you. Plenty of times when you travel with your ward or you arrange travel with your ward to go to a doctor or a rehab or medical care that's outside the county of venue, that's not perceived generally as travel. But if you're talking travel, talk to your attorney about what your circuit considers out of the travel. I mean, if they're going away for a vacation in New York, does your county consider that travel? I think they would, but talk to your attorney and find out what your circuit wants to be getting court order for travel.
Yeah, because I know my court, even if you were going to New York for the weekend, would consider that travel.
Yeah.
But if you were going to Gainesville for the weekend, probably not.
Yeah. Okay. Good point. Okay. All right. Let's keep going.
Okay. So next page, please.
Okay. Did we lose it? There we go.
So, guardianship of the person, after you've been appointed to guardianship of a person, you are going to file the initial plan, and you also annually have to complete the annual plan and the physician's report. The physician's report is due annually and must be filed within 90 days of that exam. So if I took my ward to the doctor January the 1st and my annual plan is due in May and I turn it in May, well, that's not going to work. It's got to be within 90 days. So if you file your annual plan on time, let's just say it's due in March and you took your ward to the doctor January 15th, you're good. It's within 90 days. And you also, well, you all have already taken the your as professional guardians, you don't have to take the guardian approved course because you're already professional guardians. But a family guardian has to take the guardian approved course that the court has within 120 days. Now, every circuit doesn't necessarily have the same course approved. So every circuit judge approves whatever courses they want to approve. So if somebody takes Seminole County's course and they're the guardian here in Orange County, we're going to say, okay, well, that's nice, but you still got to go over to seniors first and take that class. So that's kind of the way that works. If you're guardian of the property, they say marshal the assets. Basically, that's a fancy way of saying find out whatever the ward owns, get it all together, and make a record of it, and then file that inventory within 60 days. If you don't have all of that information within 60 days, then you just amend the inventory. And that's what you do. And if you keep finding stuff, you keep amending the inventory. I think a lot of them would like to be in the position of continually finding stuff.
All right, winner, we've got a comment from Irene Roush. So Irene says the narrow definition of right to travel is the person does not have the ability to come and go as he or she pleases, and the guardian can control this. So that's good. And it just reminds you, you can control this. I mean, travel then from that definition would mean outside the front door of the facility. So you just got to have to decide from your attorney, your circuit, your court, what version of travel do they consider to be travel that you'll need a petition and court order for you to coordinate that traveling of the ward.
And you might have to realize also that travel may differ from one ward to the next.
Yeah.
What you might allow one ward to do might not be the same as what you allow another to do. You kind of have to know your people.
For sure.
So that's kind of one of those things you kind of have to learn. Sometimes you learn the hard way.
And winner, I don't want to go too far before we forget to, you might be planning to do this towards the end, but I want to make sure that you talk to everybody about that whole NCIC thing that you discussed in person with us. I just want everybody to hear that. It doesn't have to be now, and I don't want to interrupt your flow, but I just want to make sure you explain that, which will make so much more sense to everybody of why we go through what we do when we work in multiple counties.
Okay, so the NCIC is the National Crime Information Center, and the FCIC is the Florida Crime Information Center. Okay, and the FBI controls the National Center for Crime, that one. And the FDLE, Florida Department of Law Enforcement, controls the FCIC. So the problem with that is we just got dinged a couple of, it would have been 2022, for, we get the level 2 live scans, we get the results, and we would give them to the clerk of the court. And the FDLE came to us and said, oh no, you can't do that. And we were like, what? And they said, no, you can't do that. And they said, those people aren't certified to get those records.
So you're saying that the clerks that your court, you would be sending from your department to the clerk's department don't have the NCIC certification.
That's right.
Okay, and this, I'm bringing this up, guys, so you can get it really clear, because up until winter teaching this a couple of months ago, I never understood why we have to do fingerprints in 5 different counties if we work in 5 different counties when we already did them to the state office of OPPG. And this is why. So listen to, now you'll understand, it's a pain in the butt, but now you'll understand there is some rational reason to it. So go ahead, winner.
And so they aren't necessarily, like, down in our clerk's office, they're not certified to receive the records. So I can't give them to the clerk. So when I'm writing a report, I can't even put that information in a report.
Oh, I didn't know that part. I missed that.
I cannot, because the FBI and the FDLE say that I can't. And
so who can you share that with?
The judge.
Only the
judge. That's the only person I'm going to share it with, because I can tell you federal time is hard time.
So, okay, so then I really understand this. So what that means then, guys, is let's say you worked in Orange, for example, county, which is where winter is, and you work in Lake, okay? And you do your fingerprints with the OPPG and everything's good. And then Lake says, we need your fingerprints, and Orange says, we need your fingerprints. That's because if OPPG doesn't have a NCIC certified person,
right,
they can't share it.
So they can't share it.
Right. This is, and Winter, I so appreciate you doing this, because this drove us all crazy for so long. We're like, why do we have to get the same fingerprints done in 4 different counties when we did it at OPPG? There is a reason. It drives us crazy, but now you'll understand. So this is because the person sharing that has to be certified under NCIC, or they can't share it, or they themselves can go to jail for sharing your background information.
Right. Now, what they can do is, if, like, say I get your background information and you want it, and Lake County says they will take it from you, then you can come to me. I can make you a copy, and I can get your little driver's license and make a picture of it, and get you to sign off on it, and then you can take it and give it to whomever you want.
And that's probably the most practical way because it's like one-on-one. All right, I'm gonna stop for a second because we got
Right.
questions that are going backwards, so we're getting a little out of order here. So Nancy, I'm not sure where you're headed with this. You say, are there rules pertaining to how many times an ETG can be renewed before a permanent appointment? There are, but those rules are also often extended multiple times.
Right.
So it does
It's supposed to
happen.
be twice, but sometimes it goes well past that for whatever reason. Oftentimes there's a good reason for that.
Right.
So,
There has to be a real reason.
Right.
So Danica says court order will also be, so she's going back to the travel conversation. Court order will also be needed for expenses, i.e. travel over $500. So, right. So you need the court order for that anyway. Christina says, to the question is, what option do you select when doing it? It can't be guardianship under OPPG. Cynthia, Christina, I'm not following what your subject is on that
you
one.
meaning like the ORI?
I don't know. Christina, you want to come off of mute and tell us what you're talking about? I'm not following your question.
Yeah, when you sign up to go get your fingerprinting at the office, like at UPS and things, you typically have to go and you have to sign up for it, right? When you go sign up for it, you pick OPPG, professional guardian, but that result is only going to OPPG and they're not releasing it to the other courts. So
Right. And that's why they don't release it to others, because they don't know who's certified and who is not.
correct.
So Winter, each one of the courts has their own, is that called an ORI number? Is that the right label?
Every court should have their own ORI.
Okay.
We actually, well, I have 3, but it's for different things. I have one for family guardians, one for professional guardians, and then I have another one for what is elder care and coordination. So
Okay. So that means, guys, if you've ever done, like, for example, for your kids, to be a volunteer at my kids' school, I had to sign up for Dividend. I had to do fingerprinting for that. And the ORI number went to the Seminole School District. That was their ORI number. So anytime you're getting fingerprinted, it's going to a specific entity or company or person or office that's supposed to be receiving your information. Okay, now I'm following you, Christina.
Yeah.
Next question.
Where do you get those RI number? You have to call each district and find out who's certified and what the number. I mean, that's the issue.
That's the issue.
That would be the thing to do. And a lot of times people will ask me, oh, well, I just had mine done for volunteering at the schools. Can you take that? And the answer to that is no, I can't take that, because not every ORI is entitled to the same information. So I can get, when people are doing level 2 live scans for us, okay, I am entitled to get sealed information. Some other ORIs are not. So it's different. So the assumption, people think, oh, well, I just had it done for them, and they think that the same thing is going to show up. No, not necessarily. It depends on what your ORI is entitled to get.
Right. So this is just really one of those, like, reasons why something is so aggravating. That's why.
It is aggravating.
Whatever county you work in, you have to recognize that even though they're all under the OPPG umbrella, kind of, sort of, they're also kind of, sort of not. And it might be best practice and easiest practice to simply produce a duplicate registration, all things, your 40-hour course, you pass the exam, your last 30 hours of CEs, your bond, your background check, in a package that goes to each individual county versus OP and OPG as well. And I know it's difficult, but it really is the only practical way right now to do this.
Right. And we will, I mean, like for instance, if somebody, so Sharon is the one who processes most of our professional guardian stuff. So if you send Sharon your information and you say, hey, can you share this with Osceola County? Okay. Well, first of all, we know who's FCIC, NCIC certified in Osceola County. Okay. Second of all, yeah, we'll share it. We're in the same circuit. So we'll go ahead and give it to them. So that's one less thing for you to do. But we don't have a problem doing that.
If you can't, for when you can.
Right, exactly. Yeah. When we can.
Okay. All right. Okay, guys, we could stop. I didn't want us to forget that, because that was one of the things that I came away from the presentation, that for the first time ever, I've understood why I have to do something over and over again. Irene had a quick comment. 744 allows for an extension up to 90 days upon a showing that the emergency still exists, but does not address a second extension. Right, but it happens all the time. And then Diana Shield says, are you okay with fingerprints that are not able to be checked strictly by the fingerprint because it doesn't go through correctly, meaning the FBI has to do a name check, which...
Yeah, she's talking about when APHIS can't read the prints. So what happens is APHIS, automated fingerprint identification system, if they can't read the prints, it goes through 2 times. And then once that's done, the FBI automatically goes ahead and does like a name check thing. And then we get the results of that. So once it's done twice, yeah, it's all we can do.
But that takes a little bit longer, I presume.
It does take a little bit longer.
Okay.
And it's just because it happens, and it happens a lot to women, because we tend to clean and, chemicals, wear your dishwasher detergent and all that stuff, wear your prints down, carpenters, all that sort of stuff. It wears the pads on your fingers down. So your fingerprints don't really go through very well. So yeah, that's fine.
Okay. All right. So I don't want to get stuck too long on that subject, but just want you all to hear that. All right. Sorry. Don't mean to get you off track, Winter.
It's okay. So I think we passed guardian of the property. So turn the page, please. So we do a lot of this stuff. And part of the reason why we do this stuff is, you can go ahead and click on all the pictures. These are all the reasons why we check out the people that, we check out the proposed guardians. The first is a little girl who, when I first came into this case, she was about 2 years old, and her sister, who was at the time about 19, was her guardian. Their mother had been killed by a drunk driver, and the little girl's father was in prison. Little girl's father got out of prison, came and took his daughter, and one day she made him angry, and he beat her with the buckle end of a belt. And so he was still on probation, and the sister had called me in the meantime and said, hey, he took her and I don't know what to do. So we were able to get a court order for her to go back and get the child. And she's like, I'm not going to his house. What am I going to do? What am I going to do? And so I told her, I said, well, you got a court order. When she goes to school, you show up an hour or 2 later, give the school resource officer the copy of the court order, and he'll get you the kid. So sure enough, she does that. And because she doesn't have any clothes for her, she goes and she stops on the way home to get her some clothes. And that's when she finds that her sister's been beaten with the buckle end of a belt. So in that case, I called DCF and I called his probation officer, and he ended up going back to prison, and he did time for he was originally in prison for assault on a law enforcement officer. So he did the rest of his time on that case, and then he did time for child abuse. The next case was the case of a veteran who'd had a stroke and was in the hospital over at the VA. And he was released from the hospital. But before his wife got there, his mom, who was already there, took him home with her. She didn't like the wife. And so she goes and she files for guardianship, and the wife files a counter petition for guardianship. And so the judge wanted me to figure out who was best. So every Friday for a few months, I would go get the ward, take him to meet his wife, and we would go for breakfast or whatever. This particular day, she decided she wanted to take him to get some clothes. And when we took him to Men's Warehouse, this is what we found. He had folliculitis all over his back, so you can't really see the pustules on his back, but yeah, they were full of pus. His foot was becoming necrotic, and he was, he was limited verbal ability. He could say yes and no, and he couldn't use his right side at all. So that day he did not go back to his mom. Well, he didn't ever go back to his mom, actually. He went to the VA hospital, and then eventually the wife became the guardian. And the pictures down at the bottom are of a home where a child who, well, her situation was very poor. She had been, she and her sister had been at home with their mom. It was like Christmas Eve. They were at home with their mom. Mom's boyfriend that she'd broken up with comes to the door saying he's got Christmas presents. And the oldest girl opens the door. He goes and he ties up the two girls and he kills the mom. Yeah, so he kills the mom. And so out of that, the two girls, after insurance and the sale of home and everything, they got roughly $62,000. And they were with their father. Well, the oldest girl ages out and takes her money and moves because she doesn't want to be anywhere near dad. So that leaves the 15-year-old with dad. And this is the situation dad was living in. And I was appointed to the case because the attorney withdrew, and this should have been a paying case. And he withdrew, and the annual plan wasn't filed. I mean, the annual accounting wasn't ever filed. So I was appointed to those cases. And when I went to the bank, she had $2.22. So I went to see that child, and she was still an A student. She was an honors student. And despite everything that she was going through, she was an honors student in the IB program. And when I saw her, she said, I thought no one was ever going to come.
Wow. Winter, I need a timing thing here. Do you know about how many more slides you have? I'm sorry to interrupt.
We can just keep going through them.
The reason why is Kate leaves at 4, and I can do some of the admin, but I can't run the slides.
Okay.
So, if we can pop through those, and then we can keep talking, we can. The Zoom continues, but Kate has to go at 4.
Yeah, that's fine.
Okay. All right.
So yeah, so those are the reasons why I get appointed to cases. And it's not really just about family guardians. It's about guardians, professional guardians, family guardians, making sure that the right thing is being done. Making sure that people aren't going to a facility and being there for an hour and then charging each person that they see for 1 hour. That's something that has been done to the point where one professional guardian billed 41.85 hours in one day. So we we do that because it matters. Integrity matters. It matters when you're talking about awards money. It matters when you're talking about a person's well-being also. So that's why we do that. So we can just keep going on the
slide. Yeah, pop through, Kate. Let's go there.
yeah, just go through. Because yeah, we have lots of reasons why. If you look and you can see, we've had parents buy cigarettes with money. We had a case where this one woman bought, yes, she did. She bought sex toys with her children's money. She bought that outfit with her kids' money. We had somebody who bought wine. We had somebody, the lady on the motorcycle had $7,500 worth of liposuction with her children's money.
Ugh.
Somebody bought a G-Wagon with their child's money. So yeah, it all is just about the integrity of the system and making sure that people are doing what they're supposed to be doing. As you can see hours up here, like this one where they had 25.6 hours in a day. There are only 24 hours in a day. So how could you spend 25 hours seeing people in one day? And at one point, this person was out of the country, but saw people for 27.8 hours. So I don't know how you would do that. So yeah, so you can skip that. Skip
Next
ahead.
slide.
Next. So we do, once I do my reports, I get permission from the court to go ahead and take these cases to law enforcement or the state attorney's office. And they do sometimes go forward with these cases.
Which
So,
do they go from you to the inspector general or to
no,
law enforcement? What's the order of that?
they go from me to law enforcement, and from law enforcement to usually the attorney general, not the attorney general, the state attorney's office.
Okay.
Or from me to Medicaid fraud. And then Medicaid fraud can do their own thing. So it really just kind of depends on what the situation is. If the person has Medicaid, then I'm going to call Medicaid fraud.
I see. Okay.
Because Medicaid fraud is good at what they do.
Okay. All right. Next slide. And then also Irene put over on chat, you guys, Indent2Go fingerprinting, select digital fingerprinting, then for agency select professional guardian. Irene, I presume that's only for OPPG, not each individual circuit. Is that correct, do you think? Do you know, Winter?
Oh, I'm sorry. I was just looking at this slide. I didn't hear what you said.
Irene mentioned Indent2Go fingerprinting, select digital fingerprinting, then for agency select professional guardian, but that's only for OPPG's ORI, right? Or do you know?
Ident2Go, I think, can do because we've had family guardians who've used Ident2Go. So
maybe other counties.
Yes.
Okay. Well, you guys will have to check out to make sure that if you're doing it, is it going to OPPG or Lake or Volusia or, Duval or whatever county? All right. I do want to get Kate out of here. So if there's any more slides that are really important,
no.
Okay. All right. And just go ahead, Winter. Kate, go ahead and head on home. We'll manage things. We won't be able to move the slides, but we can do that. We'll be okay.
That's fine.
Okay.
And she can share it from her computer if she needs to.
Can you, Winter? Well, we didn't have any success earlier though, but that's okay.
Yeah.
All right.
Yeah.
Go ahead.
So when I call this when things go sideways. When things go sideways, the court under Florida statutes 744-107 can appoint me to a case. And at that point, I am allowed to request bank records or whatever records I need. I can go see a ward wherever he or she may be living. I can do basically whatever I need to do to get the information I need to inform the court about what I believe may be in that ward's best interest. I can talk to guardians. I can talk to whomever. And I am a mandatory reporter as well, as is pretty much everybody in the state of Florida, but but I do report.
So Winter, when you did that last presentation, you made a comment about how you got some special authority that you can freeze accounts sometimes.
I
Because,
do.
okay, I want to talk about that. The reason why is, guys, sometimes you get appointed ETG in a guardianship that's a potential exploitation case, and you're not having success with Chase or Bank of America, or somebody's not paying any attention to your letters of guardianship. They're not locking down the account, maybe because it's joint, maybe because it's co, maybe there's a reason. Winter, can you explain how it is that you can help us when those cases happen?
Okay, so a lot of times, especially if you're talking about a case where you feel like there is a exploitation or abuse,
Yeah.
that type of thing, you can come in under, it's what we call an 825 injunction, and file a petition for an 825 injunction, and that usually goes to court within a couple of days. There's not a whole lot of lag time between filing that report and going to court, generally speaking. And so once you go to court and the court hears what's going on, they can make a decision about whether or not to freeze that person's bank account. So usually what'll happen is I'll get an order saying, or an email saying, hey, I've appointed you, I want you to freeze this person's bank accounts. And so then at that point, I go on, I look at the petition to find out where the bank accounts are. Sometimes I'll try pulling the credit to see if there are any other bank accounts that I can see or that kind of thing. And then I will just start sending out court orders to freeze those bank accounts. And those bank accounts will stay frozen until the court tells me to unfreeze them. So
And that's actually something I wasn't even aware was an option, because by the time when you're battling sometimes with banks that are not doing what they're supposed to do, and your attorney is trying to force Bank of America's legal department to do what they were supposed to do, and they're still not doing it.
yeah.
Time is of the essence. And so if you've got exploitation cases and there's a court monitor in your circuit, talk to your attorney about filing an 825 injunction, because maybe that's a solution. So we've got a comment in chat from Nancy that says, Winter came to the rescue in one of my cases where the exploitation was aggressive. That order was a lifesaver for me and my ward. Thank you, Nancy, for saying that. And I'm thrilled that that's an option, because, I think the perception by most guardians is that the court monitor is coming after you, and that's not the case. The case is they're coming after you if you're not doing your job right, but they're also there to help you with your problems if they can. So when you're stuck with a case that you can't solve a problem, reach out to your court monitor, because having them added to the case might solve the problem you can't solve.
Yeah, I personally, I don't know, people think that, but not that kind of time. So we've got in Orange County at any given time, we've got more than 3,000 cases. And Osceola County, is technically mine too. I have a case manager there, but I am the one who does any of the financial stuff for Osceola County. So if anything financial is going on, that's going to come to me. And so I don't have the time to try to single anybody out to try to go after them unless I need to. And so, yeah, my job, though, as I see it, is to protect my wards. And so if that's freezing accounts, then that's going to be, that's what I'm going to do. And that probably is my favorite thing to do in this job, is to freeze. It really is.
So, I don't really know, Winter. Do you know how many circuits or counties actually have monitors? Do you know? I don't.
Maybe 5.
Oh my gosh. Okay, well, there you go. That's not very helpful. All right.
Yeah, Pinellas, Hillsborough, Broward. Yeah, I think that's it, and us.
Wow. Okay, well, I didn't know that. Well, that's kind of sad. Okay. All right. So, Marilyn, your question was, yes, Winter is a court monitor. That's her job. When she talks about her experience with guardianship, it's as a court monitor for a long time. Okay, so it's about 4:08. Winter, the other thing I'd like you to talk about that you talked about last time was the competency court, because I really want to understand a little bit more about that for two reasons. One is it's not uncommon for us to have a ward in the correction system, in the jail system. And I have always been incredibly frustrated that the entire Florida jail system does not recognize an order of incapacity from probate. They say, we don't care about that. We only care about whether they have an order from the criminal side, not the probate side. Don't care about it. And I've always been frustrated that those two systems don't ever talk to each other. So can you address a little bit about what you talked about the competency courts and how maybe that could sometimes help us with our cases, maybe?
So competency court, unfortunately, only deals with felonies. And so there is a difference between competency and capacity. And Thelma can tell you that. I mean, because we have so many cases here in Orange County that deal with wards who are in jail. They're in and out of jail for various felonies and that type of thing. And so when somebody's charged with a felony, they are originally in just regular court, and somebody somehow has to get the message to the court that this person may have some capacity issues. Okay, so typically that's why I have a list of people that regularly go to jail. And I tell my guardians, if you have somebody who regularly gets arrested, give me their information. And when they get arrested here in Orange County, they pop up and I'll call you or I'll send you an email. Hey, did you know so-and-so got arrested for this or for that? Because a lot of times, especially if you're talking about somebody who lives on the street, that person is in jail. You don't know where they are because they live on the street. You don't know where they are until I tell you, hey, that person's in jail. And they're like, oh my gosh, I've been looking for him.
Yep.
You know, and then so this person has a case that you didn't even know they had.
Right.
And nobody's telling the state attorney or the public defender or anyone that this person lacks capacity.
And what drives us crazy is that person is not having or having medical health care treatment or mental health care treatment, and they're consenting or not consenting. And the whole thing is just a mess. It's just a mess. And
it really is.
We are stuck. We are absolutely stuck in our ability to solve the problem. It is not fun.
And it's even when they're in competency court, it's not necessarily easy. It's difficult. You know, it's one of those things, you know, I try to get to know the people who work at the jail so that if there is an issue with medication, I can call the people in the medical department at the jail and say, hey, did you know this person is on this kind of medication or on that kind of medication? Or, you know, okay, so you're sending them over to Aspire. Did you send their meds or did you send the med list? Or, you know, some of the things that happen would just kind of horrify you to think, okay, you sent them to Aspire, but you didn't send the med list.
So Winter, for counties that don't have court monitors, which is most of them, would it make sense for the guardian who's got cases that might be frequent flyers in corrections to reach out to the jail and kind of connect with the social worker or somebody at the jail to let them know? Would that be maybe the direction, or would it be the public defender, or who would be the best shot?
I would try the jail, but another thing that I would also try is one of the things that I do is when I have wards who get arrested frequently, I try to connect their cases so that when the judge goes in and puts in that person's name, okay, they can see all of those cases that are related to that person.
So connect the probate and the criminal.
Yes.
How do people who don't have a court monitor get that done? Do you know? How would we get that done?
I would say call the clerk of court, because
on either side.
right, because the
Okay.
clerk of court is who generally maintains that database.
Okay, that makes sense. That makes sense. Okay, we got a great question here. Thelma says, is there a way for us to find bank accounts for wards when we're newly appointed? So what I'm going to do, Thelma, is I'm going to paste this up on chat. It's called LexisNexis Accurate Reports. Back in the day when I was doing guardianship, I had, well, the company at that time was just called Accurate, but LexisNexis has since bought them out. Now, the problem is whether or not you can have an account. Sometimes they will allow guardianship entities like public guardians or guardian companies that have an LLC to have an account, but it's generally for law enforcement and for attorneys. Your attorney should absolutely have a Lexis, a Westlaw, or an Accurate account that you could, basically when I was a guardian, every time I got appointed, day one, I wanted that report run. It's long if it's an elderly person. It can be 60, 70, 80, 90 pages. I was helping a guardian read one the other day. It was 192 pages. And it had every possible bit of public information. So if you guys have never seen an Accurate, or it's also called LexisNexis, or it's also called Westlaw report, background check report, ask your attorney for any guardianship that you get to please run one immediately. Now, Nancy's mentioning you can also run a credit check. So for sure, one of your goals in every guardianship of the property is to lock down their credit, get those reports, find out every account that they have. Generally, the Accurate report has every account, and then you follow up with Experian and all the credit reporting agencies once they recognize your guardianship. But Jen, okay, so let's see. No, it doesn't show bank accounts. Well, it does show a little bit about bank accounts, Christina, a little bit of information. It won't show an account number. It may show a credit inquiry when you go to like Experian. So then you know check Chase, but there's a limitation of to how much information you'll get. Let's see. So then we've got Jennifer. Nancy says using SS and usual info, using social security information and usual info. You know, you guys, being a guardian is your private eye and you're an investigator and you learn how to dig. Let's talk about another subject right now. This is a hot button. We did talk about this at the beginning of the meeting. We'll bring it up for a second. I'm having to track my CE credits through FSGA tracking system since CE broker messed up my account and they transitioned the old PG number to the new numbers. Could you please send me a physical certificate for today, please? Dana, since Kate has already left the meeting, reach out to her tomorrow. She handles all that. But AGID, just so you'll know, every single webinar or presentation that AGID has done, they keep record of who attended it. So, and Kate has it where you can see that on her system. So you can print the paper copy. And by the way, all of you, you should, because this has happened with OPPG in the past some years ago where they lost people's records. You need to assume that you're responsible for your own records. Every single class you take, make a copy of it. Every single teacher, write down the name, write the name of the course, write what category it belonged under, keep a paper copy and keep a digital copy, because if CE broker loses it, if OPPG's computer system eats it, you're the one who's got the problem, not them. So assume that they're going to lose it and keep everything at least in two places, one paper and one digital. Nicola says, I have another appointment. Will I get credit for attending if I leave early? Yes, because we're past 50 minutes, so you're good. Okay, Thelma says, sometimes we just need the bank name, especially when trying to decide if they're indigent. Yeah, I know. One of my struggles in the past has been filing for a Medicaid application and getting a NOCA from Medicaid saying that not only are we denied, but they have money or property somewhere. They don't tell me what, they don't tell me where, they don't tell me what state it's in, how much it is. Is it a silver bar in Mexico or is it a car in Ohio or is it a condo in Mexico? It's very frustrating when they tell you that they won't give you Medicaid because there's an asset that you don't know about. In those cases, that's where our attorneys Westlaw, Lexis, and Public Record is the best shot. But it's nothing is perfect. Nothing gives you everything.
Right, because LexisNexis Accurate will tell you if there's an automobile or if they own property or that kind of thing.
But not bank account.
But not bank account.
One way you'll always know is when you get appointed, you always want to reach out to IRS and request the last 3 years of tax returns. If it turns out that any of their accounts had any kind of interest bearing, then they were spitting out 1099s, which means they'll show up on that IRS report. That's one way. Of course, the other way is you immediately do a change of address of every address that you know about, and every piece of physical mail that you know about starts coming to you. That's somewhat helpful. So one thing I want to talk about, Winter, because this is going to be the new world of guardianship that does not yet have a solution. So up until now, guardianship was a paper thing. You went to the house, you found the papers, you found the mail, you got all the papers. Well, we're now moving into a new evolution. Our son who's 34, probably gets 3 pieces of mail a month tops. His entire world is on his cell phone, his entire world. Every password, everything. One of the things that guardians are going to be facing coming forward is you're going to get a ward who doesn't have capacity, who can't speak, who can't tell you their password, can't get into their email, can't get into their cell phone. And you are going to have a super difficult problem because you won't know what's what and where.
Yeah.
Because they chose paperless. So when you're getting asked to take a guardianship case, think about this, because if it's a case that you have absolutely no idea what their email address is, what the password is, what the passcode is to their phone, and this is their entire world, what will you do? You think Google gives a crap about your letters of guardianship or order of incapacity? So this is going to be something was going to be a bigger problem in the next maybe 10 years. It's just starting to happen now. It hasn't been much of a problem, but it's just starting to happen now. I experienced it recently with a case, and out of pure luck and a lot of hard work, we were able to help a gentleman who had severe aphasia. I mean, unbelievably severe aphasia, be able to come up with his passwords to like 17 accounts. This wasn't a guardianship. The attorney asked me to get involved as a care manager, but this gentleman had capacity. He just couldn't speak, and he could write things down, but his writing, he had frontal lobe, so his writing is really messy, but you could make out some words. So going forward, I think you guys need to recognize we're going to need systems and ways to be able to get into a person's tech who's adjudicated, and that does not exist currently that I know of.
It doesn't.
Okay, so Betty Gall says, always ask the bank if the ward has a safe deposit box, and some banks don't link their branches about a safe deposit box, so check with each branch. Wow, holy mackerel. Okay, Betty, that's a great suggestion.
Hard to do.
I don't think I've experienced that, but boy, that's something to think about. If they don't, I mean, now theoretically, a bank deposit box has rent being paid from some account, a savings account, a checking account. Back in the day, they used to often give you a free year of a safe deposit box to open up a new account. That doesn't happen much anymore, but that's an interesting comment. Okay, so she said it happened to her. Well, there you go. So, okay, so be aware, guys, that maybe they have a safe deposit box at a different branch. The other thing to be aware of, which is crazy, is if you get a letter from a bank that they're closing a branch and they're going to move those safety deposits from that branch to another. I experienced that maybe 3 times in my career. It's a nightmare. It's an absolute nightmare. So be prepared. Diana says, is the court going to required to inform the government of any, of any undocumented guardianship cases in their jurisdiction? Okay, we're going to stay away from politics, folks, but that's a hairy question. I want to remind everybody, in our peer group, if you go into the peer website and we have this library that you log into with a password, one of the things we have is questions to ask before you accept a guardianship. And one of them is, what's that alleged incapacitated person's citizenship status. Becoming the guardian of someone who does not have citizenship or is undocumented is an entirely unsolvable nightmare. And this was before January 20th. It's an unsolvable nightmare. No Medicare, no Medicaid, no Social Security, no VA, no SSI, no SSDI. What do you do for them? It's very difficult. So anytime someone's asking you to take a case, figure out what that person's document status is. And if a hospital or a nursing home where that person's been sitting for weeks to months to years says they don't know, that's not true. That's absolutely not true. They do know. And they can have the fingerprint machine brought into the hospital and fingerprint them. So when they tell you they don't know, they're holding information back from you for a reason, because they want you to take the case. So be careful. Great question, Diana. We do not have an answer for that one. Maybe the troops are going to show up in hospitals and facilities and escort people out. Oh God. All right. So what are the other things you want to talk about, Winter, that you want us to know about?
Oh gosh. Well, the big one was about competency court. I'm trying to think of what else. What did we talk about last time other than
those are the most the subject. The jail was a big one. The you explaining the NCIC thing was a big one. That was fantastic and very helpful. And then I think I'd like to talk a little bit about the frustration that guardians are having with the Inspector General on these investigations, because what we still don't have is any kind of rules of the road. So like if Adult Protective Service or the Sheriff's Department is going to do an investigation against a guardian, there's a pretty clear path of how that works. It's pretty good information of what's supposed to happen. And it does not exist with the Inspector General. And it's been a frustration for a lot of guardians, especially when they have a case where the ward, the reason why the guardian got appointed is there's a bad guy family member or bad guy member out there who makes the same report. I know one guardian who's had the same report made against them 17 times.
Yep.
And each one of those 17 times
was investigated.
Is still being investigated. And so we're really frustrated that there's nothing we can do about that. Before you answer that, Nancy's holding her hand up. Nancy, you want to come off of mute and ask a question or say something?
Yes. So I had an experience where I was a guardian for a client whose son was allegedly possibly poisoning his mother.
Oh,
and it was the most contentious guardianship case I ever had. And for every action on my point, there was a reaction on his. So for everything I filed, he filed something back. Like I filed an order he was never allowed to bring his mother so much as a glass of water or cough drop, like nothing. She had a caretaker all the time. She lived I had her like on lockdown. And he filed a lawsuit against me, my attorney, the rest of his family members, their attorneys. And I had to hire my own attorney with a $10,000 retainer to fight this lawsuit. And then he reported me to the Attorney General and told the Attorney General that I murdered his mother.
Oh my gosh.
Yes. At the end of the day, and it took me, I had to respond to every inquiry from the Attorney General, which the amount of paperwork was egregious, because he told me that he's seen guardianship cases that lasted 15 years that didn't have as much paperwork as ours. And it was the worst experience, but it took me 6 months to clear my name with him. Oh, 6 months to prove that I got her a pacemaker so she could sing karaoke and go shopping when, he was day trading multi-million dollars of her IRA every day when a judge specifically told him no. So that is the worst situation for us, honestly.
So for now, guys, until we have the Inspector General actually submitting their policies and their rules to the Florida Bar or to us or to statute or to OPPG, please talk to your attorney. If you get a call from the Inspector General, please talk to your attorney before you have a single conversation with them, because it's being treated not like it's supposed to. Investigations are supposed to have, regardless of who it is, Adult Protective Service, Sheriff's Department, Police Department, Winter, Court Monitor, investigations have processes, policies, procedures. And the Inspector General has not shared any of that with anyone that I'm aware of. So if you get, even though your first comment, like any innocent person, is, I've done nothing wrong, I have nothing to hide, I have no reason to have my attorney, understand that where these complaints are coming from are for people trying to do you harm and not necessarily legitimate complaints. So talk to your attorney before you have any conversation with the Inspector General. So along that line, Diana says, does E&O insurance work for current cases or only forward after you pay the premiums? So I can tell you the answer to that. You get no insurance of any kind ever covers anything until you paid the premium going forward. Like if you buy car insurance and you had an accident a week and a half ago, no, it doesn't cover anything in the past. If your house burned down in September and you buy insurance in October, no, it doesn't. The problem with E&O is based on errors and omission, not criminal acts. So if you're looking at errors and omission insurance for guardianship, it might have helped Nancy hire an attorney and pay for the attorney because she was being accusations made against her. But talk to your attorney and talk to the companies that provide errors and omission for guardianship as to whether it will work to help you with what you're concerned with. Okay. Did I get everybody's questions? I think I got everybody's questions. It's 4:29. Anybody else want to ask a question? You can put up a yellow hand, you can write it in chat, or you can come off of mute and we'll let you ask your question.
Nancy still has her hand up. Oh, she took it down.
Okay. See if I can see everything. Okay, I'm going through everywhere here. Okay. Linda says, wow, that was amazing. Thank you. Okay, fine. I'm glad you guys liked it. All right, quick sales pitch. So this group is the peer mentoring group. This is under AGED's umbrella. And what you guys should be doing is attending our Zoom meetings. So we have 4 of them a month. This day, which is the 3rd Thursday of the month at 3 p.m. is always a presentation with a presenter like Winter, who was lovely enough to present for us today. The rest of the month, at 8:30 in the morning on the 2nd Tuesday of the month, at 3 p.m. on the 3rd Wednesday of the month, and at 5 p.m. on the 5th Wednesday of the month, we do shop talk. It's all it is. There's not a speaker. There's no CEs. We share forms, information, resources. Please come at least once a month, shoot for twice a month, because being a guardian is a damn difficult job. Excuse me, guys. And having the support of other experienced guardians who've been down this road might help you from having difficulties. Having a resource like Winter, even though she works in Orange and Osceola County, Winter, can they call you if they're stuck with a problem and you give them a suggestion?
With that.
What'd you say?
I said, yeah, I don't have a problem with that.
Right, right. So Winter, you want to put your information up somewhere we can see it? Do you know how to put it in chat?
Oh, there it is.
Right. And then I'm going to put my phone number, guys, for if you need to reach out to me. It's just my regular cell phone number. Anytime you need to call me, text me. If there's anything I can do to help. I do a lot of mentor work for guardianship because I really believe that we are in desperate need of more good guardians and a way to protect more good guardians, which is what I'm worried about is happening, that they're getting beat up and it shouldn't happen. So that's I'm a little worried about. All right, let's see here. Let me see how to get this, everyone. There we go. Okay. All right. Any other last questions before we sign out? I went just trying to figure out her chat business. She's going to put her information up there. There we go. So if you guys need her number or her contact information, that's Winter's information. Winter, you want to share your email or no?
Oh, I didn't even think about it.
Yes. So she's going to share her email. Again, she works in Orange and Osceola County, but Winter's a really good resource. She's been doing this for a very long time. She may know a way to solve a problem that you guys are struggling with. And that's the whole point of this group. That's the whole reason why we do all these meetings, is to try to make it a little easier. And last reminder, we do not have approval for our CE broker for Winter's presentation. We should have. It's in pending like everything else is. Kate has a record of everybody who's been on this call. The Zoom system tracks it. So as soon as we get a approval for the presentation, which we should have already got, she will send it out to everybody. And I'm sorry we're stuck, and I'm sorry. So, all right, I think we're going to wrap this up. Everybody have a great afternoon. Winter, thank you forever and so much, because now you finally answered some questions I couldn't get answers for forever. So y'all take care and stay warm in the snow in Florida.
Great.
Bye-bye, everybody.
Bye. Thank you.